Hello, everybody. Well, today is the second part of a series I started called Who is More Free? The country of today's discussion is Canada. Now, what we're going to do is go over the first three parts of the Constitution Act of 1982. That's the most recent incarnation of the Bill of Rights of Canada. As you're going to see, there are going to be some similarities and there are also going to be some differences as it relates to the U.S. Constitution and our Bill of Rights. So I'm going to discuss these first few parts because that's what deals with individual freedoms and liberties. I'm going to break them down, and then we're going to, go to comments. Any kind of questions you might have, you can leave them in the comments section. Make sure you subscribe to Chamber of Progress, and please hit that bell because then you'll be notified of any video that I drop. And with that said, let's grab some poutine, some crepes, get your hockey jersey on, and let's go Canadian. So here we are. Part 1, Canadian Charter of Rights and Freedoms. That's basically what they call their Bill of Rights. Whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law, guarantee of rights and freedoms. Okay, rights and freedoms in Canada. Article 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in the subject of any such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Okay. Fundamental freedoms. Article 2. Everyone has the following fundamental freedoms. Subsection A. Freedom of conscience and religion. This is basically saying you can have whatever religion you want. B. Freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. All right, so this is a collection here. This is basically saying you have the right to your own to thought. There are no such things as thought crimes. Okay, so that's important. And also establishes freedom of the press, of course, and any other media. That's great. So subsection C, freedom to peacefully assemble, and D, freedom of association. Ooh. Now this is something we don't have in the United States, freedom of association, because it basically means you could be affiliated with whoever you want. There is no limit on that. Unlike here in the United States, where our media, our politicians, and other institutions, they demonize people who associate with people prescribed to be America's enemies. But let's be honest, we haven't declared war since World War II, so whoever we declare to be our enemies is really unconstitutional in the way they're going about it. But anyway, Canada took care of that problem here in subsection D of Article 2, basically saying you have the right to associate with whoever you want. So Canada got it right here in a way that the United States didn't. Democratic rights. Okay, well, let's see what they got here. Democratic rights of citizens. Every citizen of Canada has the right to vote in an election of members of the House of Commons or the Legislative Assembly and to be qualified for membership therein. There's a key word here in the very beginning. Every citizen of Canada. Every citizen. So it doesn't matter if you're a woman, if you're black, if you're Middle Eastern, if you're male, if you're whatever. It doesn't matter. If you are a citizen of Canada, you have the right to vote in elections, period, end of discussion. So not only in the wording of this part of their constitution, but also just dealing with the problem of voter suppression in general, they took care of it here. Another thing they did right. Maximum duration of legislative bodies. So Article 4, Part 1. No House of Commons and no Legislative Assembly shall continue for longer than 5 years from the date fixed for the return of the rights of a general election of its members. So the duration is no more than 5 years, which is how long their prime minister lasts, how long the provincial premiers last, and the House of Commons. Pretty straightforward. All right. Continuation in special circumstances. Okay, we have something similar here, but let's read on. In time of real or apprehended war, invasion, or insurrection, a House of Commons may be continued by Parliament, and a Legislative Assembly may be continued by the legislature beyond 5 years if such continuation is not opposed by the votes of more than 1/3 of the members of the House of Commons or the Legislative Assembly, as the case may be. Essentially, this says you can't do away with the democratic process in Canada except in times of war, as determined by Parliament, basically, by the Canadian government. So that's what that means. Thank goodness Canada is not so fond of war, so that's a good thing. Very good thing. All right, what else do we have here? Annual sitting of legislative body. Yeah, annual sitting of legislative bodies, which is Section 5. Article 5. There shall be a sitting of Parliament of each legislature at least once every 12 months or once a year, because they're based on the Christian calendar. Ooh, here's something interesting. Mobility rights. Okay, this is something we don't have in the United States. Mobility of citizens. Article 6, Part 1. Every citizen of Canada has the right to enter, remain, and leave Canada. Well, you could say that's kind of the same thing in the United States, but they do make it difficult when it comes to getting in and out of the country itself. Rights to move and gain livelihood. Ooh, right to gain livelihood. This is really interesting because this is something we don't have in the United States. The right to gain livelihood. Let's see what it means. So, it says every citizen of Canada and every person who has the status of a permanent resident of Canada has the right, A, to move and to take up residence in any province, and B, to pursue the gaining of a livelihood in any province. This basically says you can live wherever you want if you're either a citizen or a permanent resident, and you can pursue whatever career you want. How do you like that? We don't have that in the United States. You can move wherever you want, but they don't give you the right to any specific or array of livelihoods. In fact, they like to outlaw as many things as possible that poses competition to the more powerful areas of economic growth. So Canada got this one right, on top of many other things too. Limitation. Okay, so there's a limitation on mobility right here. 3. The rights specified in subsection 2 are subject to A, any laws or practices of general application in force in a province other than those that discriminate among persons primarily on the basis of province or present or previous residence, and B, any laws providing for reasonable residency requirements as a qualification for the receipt of publicly provided social services. Social services. We don't have a constitutional amendment for that in the U.S. either. Okay, so basically the mobility rights here says it essentially applies to provincial needs. Okay, so whatever province, whatever their circumstances are, they can have laws, dictating how they go about doing it, but it doesn't. Those things are automatically invalid if it discriminates against people based on a different province or present province. So any kind of discriminatory law that they might try to pass, it's invalid under this part of the Canadian Constitution. So that's kind of cool. It's like in the U.S. if the state of Texas wanted to discriminate against somebody who was originally from, say, Minnesota, that would be illegal if that were a Canadian. Those are two Canadian provinces. So that's kind of cool. Now, affirmative action programs. What's this all about? Which is Article 4. Subsections 2 and 3 do not preclude any law, program, or activity that has as its object the amelioration in a province of conditions of individuals in that province who are socially or economically disadvantaged if the rate of employment in that province is below the rate of unemployment in Canada. What this basically means is any province, provincial citizens, like, I don't know, say Alberta, if some people living in Alberta have conditions that fall under the average unemployment of all of Canada, they can have special programs to help them out for that. That otherwise the Canadian government, if they fall within the spectrum of unemployment where it would qualify on the national level, the Canadian government would pick that up. But if it's lower than that, well, then the provincial government can step in and do their own thing. Legal rights. Life, liberty, and security of person. Okay. So Article 7. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. All right, fundamental justice. The word fundamental seems to be doing some heavy lifting in this statement. So we're going to read on and see what pops up here. Search or seizure. Article 8. Everyone has the right to be secure against unreasonable search and seizure, just like the United States. But unreasonable is doing some heavy lifting here again. Detention or imprisonment, which is Article 9. Everyone has the right not to be arbitrarily detained or imprisoned, just like in this country, but since when does that stop our cops, right? Arrest or detention, which is Article 10. Everyone has the right on arrest or detention, A, to be informed promptly of the reasons therefor, which is basically their version of the Miranda rights. We don't have constitutional Miranda rights. That's just an additional law. Canada actually has these laws, this part in their constitution, so they have to tell you why you're being arrested by constitutional law. So this is another area where they do better than the U.S. B, to retain and instruct counsel without delay and to be informed of that right. And C, to have the validity of the detention determined by way of habeas corpus and to be released if the detention is not lawful. So you can't be detained without cause. That's basically it. Proceedings in criminal and penal matters, which is Article 11 here. Any person charged with an offense has the right, A, to be informed without unreasonable delay for the specific offense. Unreasonable is doing some heavy lifting here again. B, to be tried within a reasonable time. Reasonable, again, a little subjective here. C, not to be compelled to be a witness in proceedings against that person in respect of the offense. This is basically a protection against self-incrimination. D, to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. The wording here really makes it so that they can't be partisan. In the United States, they don't have that. They just say, well, you have trial by jury, you have the right not to incriminate yourself. They don't say that it can't be impartial in that regard. But there is an amendment to the Constitution in Article 12, I believe it is, where it says you can't construe the meaning of the Constitution to meet your own ends, but unfortunately that still happens all the time. Here, it's basically saying you have a right to a fair and impartial trial by jury. That's what it is. Subsection E, I don't know why this is really weird the way they bulleted this thing. E, not to be denied reasonable bail without just cause. Again, this is sort of like the excessive bail and cruel and unusual punishment amendment of the Constitution in the United States. This is in the Canadian Constitution saying you can't be denied reasonable bail without just cause. But reasonable, again, doing some heavy lifting here. This seems to be a provincial thing. F, except in the case of an offense under military law tried before a military tribunal to the benefit of trial by jury, where the maximum punishment for the offense is imprisonment for 5 years or a more severe punishment. Okay, so the maximum imprisonment here is 5 years. So there you go, nothing more than that. G, not to be found guilty on account of any act or omission unless at the time of the act or omission it constituted an offense under Canadian or international law or was criminal according to the general principles of law recognized by the community of nations. This is Canada in their own constitution abiding by international law. The United States doesn't do that. So Canadians recognize here that international law, there is a general consensus of international law with regards to basic rights for all people. That's what they're saying here. The U.S., of course, in their constitution, they just say, screw everybody else, we don't care, we're going to do our own thing, and everybody can piss off. So, but Canadians, they have a dedication to equality for all people that you'll see moving forward here, as this one part here demonstrates. Okay, and H, if finally acquitted of the offense, not to be tried for it again, and if finally found guilty and punished for the offense, not to be tried or punished for it again, which is basically double jeopardy. And I, if found guilty of the offense, and if the punishment for the offense has been varied between the time of commission and the time of sentencing, to the benefit of the lesser punishment. Okay. So basically it says, let's say there was a death penalty in Canada and somebody was convicted and it was amended during the time of imprisonment and the time of their execution. If the latter, the newer one, said that the death penalty was gone and the amendment said, let's say 20 years in prison for the sake of argument, well then that would apply and the death penalty part would be gone. So that's cool. I mean, this basically says that they value life. They value human life and progressive ideology. So that's kind of cool. Okay, here we go. Treatment or punishment. 12. Everyone has the right not to be subjected to any cruel and unusual treatment or punishment. That's pretty straightforward. But again, cruel and unusual is doing heavy lifting here because it's very subjective based on individual ideology. So what might be considered harsh, a punch in the face, for example, is cruel to someone but is reasonable to someone else. I mean, you get the point. So this really tends to be a provincial term, I think. But I honestly don't know if they have the death penalty in Canada yet. I'll look that up. Self-incrimination, which is Article 13. A witness who testifies in any proceedings has the right not to have any incriminating evidence so given used to incriminate that witness in any other proceedings except in a prosecution for perjury for the giving of contradictory evidence. Well, okay, so basically if somebody's a witness and they lie on behalf of the defense or the prosecution, they can be charged. Otherwise, they can't be charged. That's what that's saying. Interpreter, number 14. A party or witness in any proceedings who does not understand or speak the language in which the proceedings are conducted or who is deaf has the right to the assistance of an interpreter. Well, that's nice. They don't have that in the United States Constitution. This is another area where they do really well. Oh, we're getting to a new section here. So the legal rights are pretty good, I think, overall. I think they've gotten into a lot of areas where the U.S. Constitution falls short. So let's go to the next one. Equality rights. There's something we don't have. Equality before and under the law and equal protection and benefit of law. That's supposed to be the case here, but as we know, people just in position of power in the United States just use the law according to their own convenience and profitability. But anyway, Article 15, Part 1 says, every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, mental or physical disability. We don't have half of this stuff in the U.S. Constitution. We've had to have separate laws that are not within the Constitution to take care of this. So this is another area where Canada gets it right. They include everything with regards to the physical being and mental being. So once again, congrats Canada, you did a great job here. Affirmative action programs, Section 2. Subsection 1 does not preclude any law, program, or activity that has as its subject the amelioration of conditions of disadvantaged individuals or groups, including those who are disadvantaged because of race, national or ethnic origin, color, religion, sex, age, mental or physical disability. Okay, so in other words, if there's anything that falls short in the provincial sense, they can pass a law to accommodate this lapse. We read this one again. I'm kind of losing my train of thought. I tend to get lost in thought when I read too fast. So again, Part 2, Section 1. Subsection 1 does not preclude any law, program, or activity that has as its subject the amelioration of conditions of disadvantaged individuals or groups, including those who are disadvantaged because of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So if anything was missed in the initial amendment read previously, the provinces can take it upon themselves to ameliorate that lapse in declaration. So that's good. Official languages of Canada. Well, we all know what they are. All right, they're French and English. Well, here we go. Official languages of Canada. Oof, hurting my head here. Article 16, Part 1. English and French are the official languages of Canada and have equality of status and equal rights and privileges as to their use in all institutions of the Parliament and Government of Canada. Good. So basically, when you get anything you read in Canada that has a dual language, like in the United States, we have English and Spanish usually. Here it's English and French. And the French version, they typically call Quebecois, which is the Canadian French version of it, the Quebec language. So let's move on. Official languages of New Brunswick. Okay, actually this I didn't know about. English and French are the official languages of New Brunswick and have equality of status and equal rights and privileges as to their use in all institutions of the legislature and government of New Brunswick. Okay, so you're kind of just you're limiting the scope here to a specific province of Canada, which is New Brunswick. Advancement of status and use. Nothing, which is part 3 of Article 16 here. Nothing in this charter limits the authority of Parliament or a legislature to advance the equality of status or use of English and French. All right. English and French linguistic communities in New Brunswick. 16.1. The English linguistic community and the French linguistic community in New Brunswick have equality of status and equal rights and privileges, included in the right to distinct educational institutions and such distinct cultural institutions as are necessary for the preservation and promotion of those communities. Nice. That sounds good. Role of the legislature and government of New Brunswick. They're doing a lot of New Brunswick things here. I wonder what the historical significance is. 2. The role of the legislature and government of New Brunswick to preserve and promote the status, rights, and privileges referred to the subsection 1 is affirmed. Okay, just declaring New Brunswick is equal under the law here. Proceedings of Parliament. Article 17. Everyone has the right to use English or French in any debates and other proceedings of Parliament. Okay, well that's pretty straightforward. Unlike here in the United States, where you get so many people complaining, speak English. We speak English here. In Canada, it's English and French, so there you go. And if not, if you don't speak any of those, they have an interpreter. Great. If you speak Arabic, Persian or Farsi, Indian or Swahili or whatever language you speak, they can have an interpreter, and you're taken care of. So, proceedings of the New Brunswick legislature. All right. Everyone has the right to use English or French in any debates. Oh, I already read that, didn't I? I think this hat's a little too tight for my head. Oof. Damn. Parliamentary statutes and records. 18, Part 1. The statutes, records, and journals of Parliament shall be printed and published in English and French, and both language versions are equally authoritative. That's pretty straightforward. New Brunswick status and records. The statutes, records, and journals of the legislature of New Brunswick shall be printed and published in English and French, and both language versions are equally authoritative. Pretty straightforward. Proceedings in courts established by Parliament, which is Article 19 here. Either English or French may be used by any person or in any pleading in or process issuing from any court established by Parliament. All right? In other words, English and French can be used in any court proceeding. Proceedings in New Brunswick courts. Either English or French may be used by any person or in any pleading in or process issuing from any court of New Brunswick. Communications by public with federal institutions, okay, which is Article 20. Any member of the public in Canada has the right to communicate with and to receive available services from any head head or central office of an institution of the Parliament or Government of Canada in English or French, and has the same right with respect to any other office of any such institution where A. There is a significant demand for communications with the services from that office in such language, or B. Due to the nature of the office, it is reasonable that communications with the services from that office be available in both English and French. There are a lot of things here about English and French being used. Communications by public with New Brunswick institutions. Okay. Any member of the public of New Brunswick has the right to communicate with and receive available services from any office of an institution of the legislature or government of New Brunswick in English or French. Okay. Continuation of existing constitutional provisions. There we go. 21. This is Article 21. Nothing in sections 16 to 20, which is the range of 16 to 20, abrogates or derogates from any right, privilege, or obligation with respect to the English or French languages, or either of them, that exists or is continued by virtue of any other provision of the Constitution of Canada. Nice. Okay. Rights and privileges preserved. This is Article 22. Nothing in sections 16 to 20 abrogates or derogates from any legal or customary right or privilege acquired or enjoyed either before or after the coming into force of this charter with respect to any language that is not English or French. Okay, so this is basically saying that the section laws abridges the customary right. So basically, it says even though that the languages of Canada are English and French, you can still speak your language. It doesn't matter. But it's just that the official ones that are spoken in Parliament, the ones that are served to you on documents and media outlets, generally will be English and French. But you could still do your language too. That's basically what that means. Minority language educational rights. Okay, this is really interesting. A lot of stuff that happens here in the Canadian Constitution you never see in the U.S. Constitution. Language of instruction. 23 citizens of Canada, A, whose first language learned and still understood is that of the English or French linguistic minority population of the province in which they reside, or B, who have received their primary school instruction in Canada in English or French and reside in a province where the language in which they receive the instructions is the language of the English or French linguistic minority population of the province. Okay, this is a continuation here, of the province, have the right to have their children receive primary and secondary school instruction in that language in that province. All right, that's not a bad one either. Continuity of language instruction, which is Section 2 of Article 23. Citizens of Canada of whom any child has received or is receiving primary or secondary school instruction in English or French in Canada have the right to have all their children receive primary or secondary school instruction in the same language. Okay. Application where numbers warrant. I wonder what this is. Subsection 3 of Article 23 here. The right of citizens of Canada under subsections 1 and 2 to have their children receive primary and secondary school instruction in the language of the English or French linguistic minority population of a province A applies wherever in the province of the number of children of citizens who have such a right is sufficient to warrant the provision to them out of public funds of minority language instruction, and B includes where the number of those children so warrants the right to have them receive that instruction in minority language educational facilities provided out of public funds. Okay. Well, this is a way in which Canadians provide public services to people who are otherwise might be disenfranchised, given the linguistic and cultural norms of Canadian life. So this is kind of cool. This is a very inclusive part of their constitution. I like it. Enforcement. Enforcement of guaranteed rights and freedoms. This is section Article 24. Anyone whose rights or freedoms as guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Well, good. This basically means that if your rights are being violated, you can sue. You can take them to court. And of course, that basically says earlier on you can't construe the Constitution's meaning, just like in the U.S., but all right. Exclusion of evidence bringing administration of justice into disrepute. Okay. Which is subsection 2 of this article of enforcement. Where, in proceedings under subsection 1, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms granted by this charter, guaranteed by this charter, the evidence shall be excluded if it is established that, having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. Okay, so basically, if someone presented evidence that in a manner that violates somebody's rights, they basically can throw it out and say we're not admitting this, or these proceedings won't go any further, or something like that. It's basically like if you don't, in the United States, if you don't get a warrant to obtain evidence to search the premises or whatever, the courts would rule that evidence inadmissible because of that. I mean, it's basically what this is. General. Aboriginal rights and freedoms not affected by this charter. Okay. The guarantee of this charter, this is 25, the guarantee of this charter of certain rights and freedoms shall not be construed so as to abrogate or derogate, I have trouble saying these, from any Aboriginal treaty or other rights or freedoms that pertain to the Aboriginal peoples of Canada, including A, any rights or freedoms that have been recognized by the Royal Proclamation of October 7, 1763, and by any rights or freedoms that now exist by way of land claims and agreements or may be so acquired. All right. This is cool because this really gives the Indigenous people of Canada constitutional rights. It's kind of shows like they have some nerve as well, you know, like, oh, we're giving you rights even though we didn't have the right to take your land in the first place. Well, you know, it is what it is there. The US did the same thing, but unlike Canada, the US, they didn't do that with their Indigenous population. They just slaughtered them all. But here in Canada, here in the Canadian Constitution, they're giving their Aboriginal people some recognition and inclusion of basic rights. That's important. Okay. So other rights and freedoms not affected by this charter, which is 26. The guarantee in this charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. Nice. So, in other words, you can't construe this Constitution to meet any selfish end you might have. You don't like somebody, you don't want them to have rights, too bad. The Canadian Constitution says you can't do that. All right. Multicultural heritage. This kind of gets to the multiculturalism that Canada is rather famous for. So here we go. 27. This charter shall be interpreted in a manner consistent with the preservation and enhancement of the multicultural heritage of Canadians. How do you like that? So this is Canada's multiculturalism personified. Whereas in the United States, you have this big melting pot. In Canada, you basically have your own culture, your own heritage. You can bring that with you, and you don't have to change it. And you can interpret the Charter of Rights with regards to that. But it's interesting there because, well, what if the culture and heritage you bring with you is contradictory to some of the other parts of the Constitution? A little muddy there. But anyway, this is meant to be inclusive. So hats off to him for the multicultural inclusion here. Article 28, it says, above here it says, rights guaranteed equally to both sexes. So this means it doesn't matter if you're a man or a woman. It's equally applied. 28, notwithstanding anything in this charter, the rights and freedoms referred referred to in it are guaranteed equally to male and female persons. Well, isn't this great? This is something that took a long time for Americans to come to their senses to. So they already applied rights equally to men and women, including the right to vote and anything else. So awesome sauce. Rights respecting certain schools preserved, which is 29 here. Nothing in this charter abrogates or derogates from any rights or privileges guaranteed by or under the Constitution of Canada in respect to the denominational, separate, or dissentient schools. Okay. The charter derogates. Okay, dissentient schools. Essentially, this basically says you can teach. This basically has the right to independent education, right? Like there's no arbiter of truth. That's kind of what they're saying here. Application to territories and territorial authorities. This is Article 30. Sorry. A reference in this charter to a province or to the legislative assembly or legislature of a province shall be deemed to include a reference to the Yukon Territory and the Northwest Territories, or to the appropriate legislative authority thereof, as the case may be. Okay, so I'm guessing this is in response to the expansion up into the northwest part of the Canadian territory. So, I honestly hadn't learned everything about that yet. So anybody, if they know anything more on this that I missed or misconstrued, please let me know in the comments section. I'll be more than happy to remedy that. Legislative powers not extended. Okay. 31. Nothing in this charter extends to the legislative powers of any body or authority. Nice. So basically it's saying the rights of this charter apply to the people. All right. It just applies to the average Canadian citizen. Application of the charter. All right, here. Application charter 32. This charter applies, A, to the Parliament and Government of Canada in respect of all matters within the authority of Parliament, including all members of relating to the Yukon Territory and Northwest Territories, and B, to the legislature and government of each province in respect of all matters within the authority of the legislature of each province. Okay. Basically saying it applies to everybody, as provincial arrangement may be here. Exception. Oh, part 2 of 32. Notwithstanding subsection 1, section 15 shall not have effect until 3 years after this section comes into force. So this is something that's resigned to history. Already happened. Exception where express declaration. Okay. 33, part 1. Parliament or the legislature of any province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate, notwithstanding a provision including in section 2 or sections 7 through 15 of this charter. Yeah. Operation of exception. Here we go. Which is part 2 of section 23. An act or a provision of an act in respect of which a declaration made under this section is in effect shall have such operation as it would have but for the provision of this charter referred to in the declaration. All right. 5-year limitation. This is subsection 3 of 33. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force, or on such earlier date as may be specified in the declaration. All righty. Reenactment. Number 4 of section 33. Parliament or the legislature of a province may reenact declaration made under subsection 1. All right. 5-year limitation. Subsection 3 applies in respect for the reenactment made under subsection 4. Okay, they're basically trying to reiterate things according to the provincial layout. Citation number 34. This part may be cited as the Canadian Charter of Rights and Freedoms. Nice. Let's go to the next page. Okay, part 2. Rights of the Aboriginal Peoples of Canada. So this is basically dealing with their Indigenous population and the rights that they have under Canadian law. So recognition of existing Aboriginal and treaty rights. 35, part 1. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Awesome sauce. Inclusion. Love it. The definition of Aboriginal peoples of Canada. Section 2 of 35. In this act, Aboriginal peoples of Canada includes Indian, Inuit, and Métis peoples of Canada. To be fair, I don't know who all these groups are labeled as, but I'll find out. Land claims agreements, which is section 3 of this, 35.3, I guess you could say. For greater certainty, in subsection 1, treaty rights includes rights that now exist by way of land claims agreements or may be so acquired. Okay, so unlike in the United States, they're actually defining the kind of arrangements they have with the Indigenous people and what they actually mean and how they apply to the rights of the Indigenous people. So this is good. This is, again, very inclusive, recognizing that they're sharing the land with these people and that they should live together. So, good. Aboriginal and treaty rights are guaranteed equally to both sexes. Good. Men and women both. So, subsection 4 of 35, the government, what is it? Both sexes, okay. Notwithstanding any other provision of this Act, the Aboriginal and treaty rights referred to in subsection 1 are guaranteed equally to male and female persons. Equality of sexes, great. Commitment to participation in constitutional conference. Okay, so inclusion in legislative matters, basically. 35.1? The bullet system of this Constitution is really weird. Anyway. The Government of Canada and the provincial governments are committed to the principle that before any amendment is made to Class 24 of Section 91 of the Constitution Act of 1867 to Section 25 of this Act or to this part, A, a constitutional conference that includes in its agenda an item relating to the proposed amendment composed of the Prime Minister of Canada and the First Ministers of the provinces will be convened by the Prime Minister of Canada, and B, the Prime Minister of Canada will invite representatives of the Aboriginal peoples of Canada to participate in the discussions on that item. Good. This basically is saying that at both the provincial and federal level, the Prime Minister of Canada and the Premiers will include the Indigenous people in the discussion. Unlike this country where, we're racist as hell in this country, unfortunately. And we just saw Indians as savages and we just killed them, most of them off, and took everything they had. And we were brutal. So, unlike the United States, Canada includes their Indigenous people in their political discussions. So, way to go. Now we get into part 3. This is the final part we'll be talking about today. Equalization and regional disparities. Okay. Commitment to promote equal opportunities. Again, when it comes to gaining a livelihood. This is interesting. 36.1. Without altering the legislative authority of Parliament or the provincial legislatures or the rights of any of them with respect to the exercise of their legislative authority, Parliament and the legislatures, together with the Government of Canada and the provincial governments, are committed to A, promoting equal opportunities for the well-being of Canadians. Yes, we don't have that here in the United States. B, furthering economic development to reduce disparity in opportunities. And C, providing essential public services for reasonable quality to all Canadians. Hence their healthcare service, right? That's why they have universal healthcare in Canada. Even though it's on a provincial basis in some areas, there's some basics that they have in their healthcare system that all Canadians have. So that's good. Good. I wish we had that here. This is almost like an economic bill of rights in a way, or at least an outline for it. So way to go, Canada. Good job on that. Commitment, respecting public services. I wish we had that here. That's actually what my priorities amendment is for, and I might make a separate video about that. So anyway, Part 2 of Section 36. Parliament and the Government of Canada are committed to the principle of making equalization payments to ensure that provincial governments have sufficient revenues to provide reasonably comparable levels of public services at reasonably comparable levels of taxation. Okay. This is almost like what my priorities amendment is talking about. I'll probably will go into that later. But the government is making sure that all provinces have enough funding for their public services so that Canadians have a basic standard of living. And this includes their health care, pensions, and whatever other provincial services are agreed upon by the provincial legislatures. That's awesome. That's awesome. We don't have that in this country. We have states' rights and everything, but they have to go to the federal government, and the government has to determine whether or not the states can get the funding. This is guaranteed under Canadian law that the Canadian provinces will get their funding. They don't have the guarantee in the United States Constitution. So again, another area where Canada gets it right. So that's all we're going to be discussing today as far as that goes. After that, we have Part 4 says repealed constitutional conferences or repealed. A lot of this just has to do with government operations and how the provincial governments and federal government operate in tandem and separate with each other. But the first 3 parts here basically deal with Canadian rights. So there you have it, the Canadian Charter of Rights and Freedoms. And maybe even a little bit extra here. But what I find interesting about the Canadian Charter of Rights and Freedoms here, they include everybody. They include all Canadian citizens based on whatever they look like, whatever sex they are, whatever their nationality might be, whatever their language might be. They're very intricate about the language here. Even though the national language of Canada is French and English, they make room for people who don't speak either one of those languages. Give them an interpreter. They can still participate in the process, education, and so forth. And of course, they have a commitment in their Constitution to public services, unlike the United States. So now that we've read all that, make up your own mind, guys. Who is more free, the United States or Canada? Leave your comments in the section below. Again, subscribe to the channel Chamber of Progress and click the bell to make sure that you're notified of whenever we drop a new video. I hope you enjoyed this. The next country on the list is Japan. So the Japanese Bill of Rights will be discussed next. Watch out for that. And I hope you enjoyed this discussion on Canada today. Peace out.